So welcome everyone. My name is Reedy Mukopade. I'm an attorney with the Sexual Violence Law Center. Thank you so much for joining us. Uh, we are excited to start off this year with our Lunch Matters series, just focusing on issues related to serving survivors. And Yvonne, do you want to start off by talking about the program?
Yeah, hi everyone, welcome. Thank you for sharing your time with us today. Most of you know what we do at the Sexual Violence Law Center, also known as SVLC, but for those who don't, we are a group of attorneys, nonprofit organization, and we provide holistic legal services to survivors of sexual assault statewide in Washington. We provide what holistic services, legal services means to us is that we address the situation, the problem, where most victims of domestic violence and sexual assault, when they have to engage with the legal system, they often have more than one legal issue. And so instead of having 3 different attorneys or choosing one issue to prioritize and letting go of the rest, we try to take on as many of those legal issues as possible for representation, for consultation, and then when it's appropriate, we do refer certain cases out. You can see on the slide our practice areas. It's a pretty large scope. I'm not going to read it to you. It kind of annoys me when people just read from a slide because I can do that too. But if you guys want a copy of the slide or want more information about our program, you're welcome to visit our website or email any one of us. We do full litigation, consultation. We have a statewide free legal line. So if you ever have questions or you have a client who has questions, feel free to call us. Only attorneys pick up that line. Only attorneys answer the emails. And that is kind of a good short summary of our program. Did you want to add anything, Reedy?
No, just that, yes, actually that we serve survivors of all gender and all ages. There's no age restriction on who we serve. And Bushra, who's with the South Asian Bar Association, we're actually partnering with the South Asian Bar Association to provide legal services, pro bono services. So Bushra, do you want to share a little bit about the South Asian Bar Association of Washington?
Yeah, thank you, Riddhi, and thank you, Yvonne. Bushra Rahim here with the South Asian Bar Association. I'm currently sitting on the board as secretary and chair of the legal clinic. I believe we have with us today the president of SABA, Rania Rapersad. Hopefully we can look for her, but and she's also the founder of the Joint Minority Mentorship Program, JMM. And speaking of our mentorship program, JMM is currently recruiting mentors and mentees for our annual mentorship program. JMM is a partnership of several minority bar associations hosted by SABA, which pairs mentor lawyers of all backgrounds with mentee law students and new lawyers of any and all historically underrepresented groups for a year-long program. We're looking for attorneys who are interested in becoming a mentor. We have our kickoff event Tuesday, March 2nd. I will link the registration if it's all right with you, Riddhi, in the chat box. And then also, if you're interested in providing representation in a pro bono capacity, SABA has, like Riddhi mentioned, a very exciting virtual pro bono legal clinic, hopefully starting in March. And we would love to have you participate. We'll have a virtual sign-up sheet sent out. And we're looking for attorneys with any and all skills, with any and all backgrounds and expertise. So thank you so much for letting me speak, and thank you for being here.
So we would like to know who else is in the room. So just a quick poll, who else is in this virtual room? If you can take a minute to fill this out. Okay, we're at 30 seconds. So I'm gonna launch, and it looks like we have a lot of expertise in can folks see, can you give me a thumbs up if you can see the poll results? I just don't know if I'm the only one who can see it. No? Let me share results. Does that, okay, can you see it now? Okay, perfect. So it looks like we actually have a lot of expertise here in the virtual room with us. For folks who identified as being involved in other capacity, if you wouldn't mind just putting in the chat in what way, it's much appreciated. Another, because we are also working with survivors, it's helpful for us to also know who do we have survivors in the room. So this is my second question to everyone, if you can take a few seconds to answer. Okay. So just always a reminder, regardless of the profession, regardless of the community that we're in, that there are survivors among us. And so to be mindful in how we're talking about abuse and sexual assault, and also for anyone, all of us who are doing this work, and for survivors who are doing this work with us, please also definitely step away, turn off your camera, take a break if you need it. Today's topic hopefully is not as triggering as some other topics can be. We're talking about Zoom. So hopefully this will be an easier topic to go through. Okay, and last series of questions. We want to know your experience with remote hearings so far. So there are 2 questions here. And if you can take about 30 seconds to answer. Okay, it looks like it slowed down. So looks like we have quite a bit of experience here. And that's great because we actually do want feedback from folks about best practices that you've been seeing or engaging in, because we want to be able to learn from each other. Well, thank you for sharing. And let me close the poll. So with that, since folks have actually quite a large number of you have already been doing remote hearings, Yvonne, do you want to drop the Jamboard link in the chat? Did you? Okay. So if you can click on the link that Yvonne is about to drop in the chat, it should take you hopefully to the Jamboard, which, let me see. Are others able to join the link through the link? If you click on the link. Oh, okay. Now it's saying, okay, I'm so sorry. Let's do this via chat then. What are some of the difficulties that folks have seen with having remote hearings? And if you can take about 2 minutes to type in some of the maybe difficulties that you've witnessed or you've experienced with the remote hearings that you've participated in.
And I'm going to read the chat too while we get them. Connection and audio issues, unable to have private conversation with clients, getting knocked off. Yep. Talking with clients. Clients having challenges connecting on conference line, confusion due to language access, audio, can't object properly.
Anything else?
No ability to call back if disconnected. Hard to use exhibits. Yep. You know, I actually was on a telephonic hearing once and I got disconnected and I called back and kind of got scolded by the clerk. They said, "You're not supposed to be calling this line, but I'll let it go this time." Like, oh, thank you. I'm having a hearing right now. I appreciate that.
One thing I find really difficult about, the remote hearing process is an amazing opportunity. It really does expand access for a lot of the clients we work with, but there are definitely a lot of barriers that we still haven't figured out, and as a community that we're slowly figuring out now. One thing that feels really, I didn't think about it before, but I really hate the fact that I can't see like the opposing party's body language, or a lot of times with the telephonic hearing, I don't know if the judge is angry at me or if the judge is wanting me to stop talking, or maybe they're confused and maybe I should be talking more. And that's one of the sort of downsides, I think, of the remote process. Well, thank you for sharing. I don't see any other comments, but if you think of anything else that you want to share, please do use the chat to share with everyone. So there are sort of two ways to actually, Yvonne, do you want to take this slide?
Yeah, so when we think about preparation for our remote hearings, traditionally we think about preparing the client in a chronological or linear way. Before the hearing, the pre-hearing stage, the actual hearing, what we're going to be doing during the hearing, and then post-hearing. For remote hearings, those three categories that we break it up into, or try to think of it as the place, like how you prepare for the hearing, practice, still pre-hearing, practicing for that remote hearing, and then presentation for the hearing, and what that will look like.
So we can't be talking about working with survivors, and even with when we're talking about technology, if without talking about trauma and how trauma manifests with the survivors we work with, especially in kind of a more heightened situation like a hearing. We're here to be better advocates and for survivors, and we can't do that unless we're really trying to engage in trauma-informed practices. So that requires understanding trauma and understanding the client's perception, how that trauma is affecting the client's perception of the world. So many of you have probably seen different presentations on trauma. There's the sort of basic definition of trauma, which is it's an event that or a series of events that creates, I think people keep getting dropped off, sorry, that causes physical harm or emotional harm, psychological harm, and that can end up having a lasting harmful effect on them. There's also another way of approaching trauma, which is the adverse childhood experiences study, which is more of a public health perspective. There's also the big T versus little t trauma conversations about kind of big experiences, or I don't want to say big experiences, experiences that socially we identify as traumatic, but also a lot of the ongoing traumas, the smaller traumas that usually society doesn't identify as traumatic, but can really leave a lasting impact on the survivors. Neurobiology of trauma, when you're thinking about the brain and how the brain responds to trauma. I'm just really touching on a lot of different ways to talk about trauma. We can talk about these at a different training in more detail, but because we have an hour, just wanted to kind of touch on it. I have Maslow's hierarchy of needs, this pyramid up here, because I think when talking about trauma related to the legal system, it's helpful to kind of think about where our clients are often at. Maslow's is basically motivational theory around the psychological factors of human needs. So basically, it's sort of a bottom upwards hierarchy where you start from the bottom, and once some of the foundational needs are met, then you can kind of move towards self-actualization. So you start out with the physiological needs. And once you meet your physiological and your safety needs, then you can move up to more of the needs related to love and belonging, like friendship and social circles, and then finally move up to self-actualization. But one thing that is hard about trauma is that the legal system is usually working at the top of the pyramid. This is where we have to think chronologically, where we're supposed to be rational, we're not supposed to be emotional, we're supposed to be respectful to the opposing party, who in a lot of our cases is the abuser and has been a source of long-term harm and trauma. And so the legal system's often asking the survivors that we're working with to be functioning at the top of the pyramid, when the reality is that a lot of our clients, a lot of our survivors are actually struggling kind of at the base of the pyramid. Maybe their bodily autonomy hasn't been respected. They don't have a sense of security. They don't have a safe place to sleep. They're having a hard time sleeping. And so the nature of trauma often leaves our clients kind of struggling more towards the base of the pyramid. And this is the inherent conflict with how the legal system works and how the legal system works to respond to trauma. The other aspect of this is specific to remote hearings, is unlike coming to court, remote hearings is an invasion of what might be a safe space for some people. The court is basically reaching into survivor's home, and in some ways, the opposing party also has more access to survivor's private space that they normally wouldn't have access to. So there's also that part of kind of thinking about these needs and what does it mean to be talking about a traumatic event in a space that normally would feel safe and comfortable, but you're also exposed because you're going through this hearing process. With trauma, there's also, we talked about traumatic barriers, but because we're talking about virtual hearings, it's important to also think about tech barriers. Yvonne, do you want to talk about this one?
Before you talk to your client about how to prepare for their remote hearing, whether it's telephonic or video, it's important to keep in mind how that client engages with technology. Technology intersects with so many aspects of our lives now, but there's still a lot of complicated components to keep in mind, especially when we have a client engaging in the legal system because they're trying to get safety. One of the first things to consider is how your client uses technology. Is it mainly social? Is it for their kids? Are they using it for work, for school? What kind of platforms are they using and for what purpose? The less somebody engages with technology, the less comfortable they're going to be going into the remote hearing. Think about access, how much access they have. A lot of our clients don't have access to a computer. They may have a smartphone, or they may not even use email. And so telling somebody who is not used to engaging with technology that they now have to appear on a Zoom call can feel very intimidating, and it's just another layer of stress for them. Not only do some of our clients not have access to technology, some do have access, but it's not safe access. They may be living with their intimate partner who has been perpetuating violence against them. They may not have a time or space that's safe for them to log on. I know that this is something to talk to them about. Like, do you have access? What are you comfortable with? Do you have safe or private access? A lot of our clients have kids, so there are certain times when it is okay for them to be on the phone with us talking about their case or being at a hearing, presenting at a hearing, and other times where they're not going to have the privacy or ability to engage with the court system because they have children to take care of or others to take care of. Think about, so that segues right into the privacy aspect, where they and how they can access technology in a safe and private way. People are more active on social media without really thinking about who is seeing their posts. Tech companies are changing privacy settings, but a lot of people, when they sign up for social media accounts, they just accept the default settings, which is not the most private setting. Think about who has access to your client, who can see the information that your client has, and you can help walk them through better privacy settings. And last but not least, safety. Think about your client safety. When your client is engaging in a remote hearing and it's a video hearing, it can feel very invasive. It's kind of a double-edged sword because there are times when our clients don't want to go to court because it's a hardship. There's a barrier to travel. They don't want to be in the same room as the perpetrator. But on the other side of the coin, having a remote hearing and having it by video it feels like inviting the perpetrator into your home. And I think a lot of you as practitioners can understand that now that we've all been working in a pandemic and have been working from home. You're now talking to your clients in your kitchen, in your bedroom. I have talked to clients in my closet, in my bathroom. Like, my clients are in my house all of the time. And so think about how that has been affecting your work and your ability to create limits for yourself and barriers and safe boundaries to avoid burnout. And now imagine what kind of situation that puts a sexual assault survivor or a domestic violence survivor in. Wherever they are in their house, they're now sitting with that person in front of them. Privacy and safety can overlap, but privacy is much more about, when we think about access to the client's information and safety. So it's good to prepare your client for what to expect, so that they can pick a space where they're going to be safe, where they can have privacy, maybe a place that they don't go to too often, where they have a nice clean back barrier, which we're going to talk about in a moment. Sorry, not a barrier, a background, so that they're not like in bed in the hearing and then having that space be infiltrated in that way.
Related to the space conversation, I mean, some of it's also just visual, right? Like a well-lit place so that we can see the client, so the court can see the client. Like Yvonne talked about, also making sure it's a quiet place. How often have you been frustrated when your phone is at 10% and you thought it was fully charged? So really thinking about also power source, not only talking to your clients. And we're talking about your client. We keep saying like your clients and the survivors we serve, but this also applies to you. Paying attention to how charged up your devices are, making sure you're close to a power source, talking to your clients about being close to a power source. I've actually been on calls with my clients and where we've essentially kind of done a walk through their home, trying to figure out where their Wi-Fi hotspots are, where they're going to have a stable connection. Because, I have clients who may be borrowing internet from their neighbor, and because it is expensive to have internet, and they don't have the benefit of just being able to hook up a cable to ensure that they have a stable Wi-Fi connection. Sitting or standing, it seems really basic, but really talking to the client about like how long this hearing might be. When we're in court, it's okay to like step away, go to the bathroom if your case hasn't been called. As an attorney, I can call the client back if they need to like kind of step out, but there isn't that same sort of informality, even though it may feel informal because you are in sort of a home setting or a non-court setting. But talking to the client about figuring out a location that they're going to be comfortable in for a while, but not so comfortable that it's disrespectful to the court. I've been in meetings and, where somebody's sort of half lying on the couch with the laptop on their on their stomach, and it just looks like they were just watching Netflix. And so also making sure that comfort is considered, but not to the point where the court may find it disrespectful. Another aspect of the comfort is thinking about who else is around. Yvonne talked about like a space where maybe the abuser has access to, but also if the client has roommates, if the client has children, if the survivor is going to be talking about, in our case, a lot of times they're talking about really painful, intimate details. And they may not feel comfortable sharing as much if their children is around, but we want to make sure that there's a clear record for the court to be able to make a decision on. So talking to the survivor about who might have access to that space and and thinking about their comfort and what are they comfortable sharing. And then Yvonne also talked about the background, making sure there's no identifying information that could maybe give away a survivor's location, especially if it's confidential, or pictures in the background that could lead to additional stalking or doxing. So those are some of the aspects of preparing related to the place. Yvonne, do you want to take practice?
Yes. So prior to the remote hearing, if it's going to be a Zoom hearing, so prior to every hearing, I have a hearing prep meeting with my client. If it's going to be a Zoom hearing, then I do a Zoom prep with them, have them download it or walk them through downloading it, downloading Zoom, creating an account, checking their mic, checking their sound, audio, and visual. I remember the first time I had a remote hearing. That was one of my first concerns, was how am I going to talk to my client? Because usually you have the benefit of sitting next to your client at counsel table. And so one of the things that I do is I talk to my client about whether or not they have access to any messaging or chat apps. A lot of our clients have Gmail or use Gmail as their primary email. And if you have Gmail, then you have access to Google Messenger. So I'll have my Zoom hearing window up in one space, and then on the side of my computer, I'll have Google Messenger. And I've been on Google Messenger with my clients and their legal advocate, so that we can text with each other in real time to talk about any issues that come up during the hearing. We practice going through the hearing. So logging on, having their video off in the beginning if needed, muting and unmuting. We check to make sure the video is clear, that the audio is clear, that they're well lit. You just run into a lot of tech issues if you don't practice. Lighting is really important, especially if it's a video hearing. The court needs to be able to see your client's face. Just as if we were in a courtroom, they want the benefit of being able to read your client. So having them well lit is really important. Most of our remote hearings have been protection order proceedings. And so those proceedings are typically mostly declaration based, but sometimes the court will request testimony. So it is a good idea to go through all of those steps and check. And I think we also are going to have a space later because I would love to hear about other practice tips from you all and how you prepare for your hearings.
We're talking about clients, but also related to the fact that sometimes we'll have a commissioner or a judge who really wants testimony from everybody and also wants witnesses. A lot of times with the sexual assault protection order cases, they're actually treated like mini trials. And so often the court is wanting to hear from witnesses and declarations aren't enough. So also really think about with your practice, applying that practice to witnesses as well and talking to them about what does it mean to be waiting as a witness virtually. In court, it's different, right? They may be waiting in the hallway. It's a lot easier. But as a witness who does not maybe have the kind of relationship you do with your client, it's still important to keep in mind that the witnesses also need the same consideration. With platforms, Yvonne talked about practice. I actually, if I know the kind of hearing I'm going to have and the kind of platform it's going to be, I will actually start having all of my meetings like that. Like I will try to have all my client meetings with that client over Zoom. As much as I hate Teams, I will try to use Microsoft Teams to meet with the client. So both of us are comfortable at least with the platform, and it's not just like the day before. And now there's all this panic because there are issues with the platform. Even we keep talking about virtual as in like video, but telephonically too. Something really, really basic. For example, in King County, on the family law docket, the commissioners will call out to the client and the parties. But on the anti-harassment sexual assault protection order docket, we actually call into the court. So even those little differences, it's important to be paying attention to, because if you have a client who has maybe on their phone the spam, I don't know, you block any spam calls, a court call is going to get blocked. And then that can be problematic and make it seem like the client is not being responsive. I've gotten into trouble because I didn't realize that I had that block on my own phone. So to really be paying attention to those little nuances and try to make it try to normalize it by making it part of your ongoing meetings and your ongoing communication with your client. So we're talking about practicing, and then comes the part of actually presenting in court. This is always good advice, regardless of if it's in person or remote, but check in, call in early, check in early, make sure that your client has all the information. A lot of times, you've emailed the information, you forwarded the information, but that was a couple of days ago. The client may not have it ready. So make sure that they have it available to them the day of, and check in beforehand. I already talked about like court calls being identified as spam if the court is actually calling out. So making sure that that filter is turned off. I had a client where they couldn't for some reason, when the court was calling them, the call was just not going through. But I could talk to the client. And so then I conferenced the client in, and it was fine. The same thing happened with a different commissioner, and the commissioner was not okay with me conferencing in the client. So just also recognizing that what works in one court may not always work with another court, and being prepared for those unexpected obstacles. Really practicing being on mute, and especially in the virtual world, because of the lag in connecting, because of connection, especially because we're often we've got our adrenaline up, our clients have their adrenaline going, there's a tendency to talk faster, not pause. It's really, really important to talk with the client about pausing before speaking and taking those breaks. As silly as this sounds, looking at the camera, depending on how the laptop is set up, how the phone is held, for the video hearings, it's helpful to remind the client to be looking at the camera. This is where practicing ahead of time also is really helpful, because that way you can see what the camera angles are and how it's going to look from the court's perspective. Because we're working on protection order cases, because we're working on cases where a lot of times the respondent has been the source of abuse and serious trauma for our clients, we actually recommend to our client, or I recommend to my client, that they can cover up the respondent's face once their face is on the screen, because that's also really jarring, I think, for a lot of clients to just have this like face literally in your face if you're on a video in a video hearing. And then lastly, making sure that the client has renamed themselves, that their name is visible, and it's accurate. This is not the time for cute names like sexy 69. Like, I don't want to see that on the Zoom. I'm sure no judicial officer wants to see that name. And so making sure to talk to your client about renaming themselves, making sure that you've renamed yourself, depending on if your kids have access to your platforms and have been using your account. Yvonne, you want to keep talking about presenting?
Yeah, so have, just as if you're preparing, for in-person hearings, have all of your documents ready. Any documents that would be useful for your client for the hearing, help make sure that they have access to those documents. Protection order proceedings, we typically don't have exhibits, but I have presented exhibits in person. So have your case file ready, just as if you were in person going to court. Every court has different methods or practices for how exhibits can be presented. You still have to give opposing counsel, the first look at the exhibit, and before you present the exhibit to the court, ask if the court has not told you ahead of time or given you instructions on how exhibits are going to be presented. Then just ask the court how they would like it. Do they want you to email it to opposing counsel first? Do they have a share file link that you can use? Are they using Dropbox? But you should still be able to get your exhibits in. It's just a matter of how. And as long as you are flexible about it, I think it can be done smoothly. It just takes a little bit longer because you do need to present it to opposing counsel first before you present it to the court. With interpreters, let the court know ahead of time that an interpreter is needed. Sometimes they will write it on the order, and sometimes it gets left off. So just make sure prior to hearing that you are emailing the bailiff or emailing the clerk to let them know that an interpreter is needed. and see if live captioning is available if it's going to be a Zoom hearing. For client conferencing, for Zoom hearings, the court typically will allow you to go into a breakout room with your client. So if you need a recess to speak with your client for a few minutes, let the court know. And recording, parties are not supposed to record hearings, but the court does have authority to record it. Some courts have live streaming. Pierce County, for example, live stream their hearings. So you can go onto the Pierce County website. I think the platform they use is YouTube, and you can watch, or actually, I don't know if they're still using YouTube, but you can watch hearings live. Those, I actually tried to get a copy of one of my Pierce County hearings, and they told me that they don't record the video hearings. It's only live streamed. So it's just good to know going into it what to expect so that you can let your client know if they're going to be recorded and what format that's going to be in and who's going to have access to that.
With the live streaming also, it's helpful to know ahead of time because for example, if you have a client who's been a victim of stalking and they've been a victim of online stalking, having that hearing live streamed publicly, even if it is for a short period of time and it's not going to be permanently accessible via YouTube, that can be a really terrifying prospect for the survivor that you're working with. So also just knowing what's going to be happening with the recording for a virtual hearing, it gives you a chance to also proactively maybe try to ask the court not to live stream this particular hearing if it's possible to try to take some protective measures to ensure that the client's privacy and dignity are maintained throughout the hearing. It's hard to know sometimes in the moment because the courts are also changing and adapting and evolving in how they're using technology right now to do remote hearings. So because you were in front of a commissioner or a judge 3 months ago and they handled a hearing a certain way, doesn't mean that the technology is still being used the exact same way. The court may have evolved. So it's also really important to be checking in to make sure that you understand exactly how on the court's end they're going to be engaging and using the technology for the hearing.
I wanted to just add, most of my hearings, the court has required everybody to have their video on, but I did have a hearing with a minor, a victim who was 14 years old, and the court was really thoughtful and trauma informed and allowed her to keep her video off. If she had to testify, then she would need to turn her video on, but otherwise they let her keep it off for the whole time, and that made her feel a lot more comfortable and safe in the hearing. So if your client is going to feel more comfortable with their video off, it's worth asking the court if that's a choice that they can make.
Yvonne, you had also shared with me that I actually really like this. I hadn't been doing this, but you actually let the court know ahead of time about like where your client might be looking. And I thought that was great.
Yeah, so if one of my clients she only had Google Messenger on her phone. So one of the things that I like to do for video hearings is let the court know, Your Honor, as an administrative matter, I just want to let you know that while we typically have the benefit of being next to our clients at counsel table at hearings, because this is a remote video hearing, my client can only communicate with me via Messenger. So if you see that she is looking off screen or looking down at her phone, please know that she's likely communicating with me, and it is by no means a sign of disrespect or an indication of how seriously she takes this hearing. In courts, I've always been like, oh yes, of course, that's fine. But I think sometimes it's good to remind the court or let the court know, because normally when we have conversations with people, if they're not looking at us or if they're on their phone, it looks like they don't care. So to give the court a quick heads up, I think helps make the hearing smoother.
I think also I just blanked. Never mind. So with that, it's also helpful to always have a backup plan, because we know technology can be a savior, but they can also fail us and be a pain in our ass. And so, really making sure the day of that you have everybody's email address, not just your witness, not just your clients, not just opposing counsel or opposing parties, but also the courts. Especially for a court that I have not been in front of, I will contact the bailiff ahead of time to find out, like, does the court actually have a process in place if, the the call drops, or if the video cuts off. I'll also ask the court about, what is the contact information, who should I be contacting if there are any issues the day of. We've seen this happen where, the client's been waiting to get called by the court, and the court never contacts them because the court had the wrong phone number. And then the survivor is struggling to figure out who do they contact to make sure that their case is actually called and the protection order isn't dismissed. So making sure as your backup that you have all the contacts that you need. Figuring out with the client about the callback options, and also figuring out with the client if there's no connection, because there's already the technology stress, there's already the hearing stress, there's also already the regular trauma that the client is dealing with, the survivor is dealing with, and then suddenly the call drops or the connection is lost, and everything can explode in our client's mind at that moment. So just letting them know that just because we're connecting to the court, just because we're involved in a case, it doesn't mean that the court is any more sophisticated than we are about technology. And call could drop, connections can be lost, and really preparing the client for that possibility so that when it happens, it's not a shock. And earlier I talked about comfort. It also connects back to this idea of appearance. Talking to the client about dressing for court. I think they always talk about you dress for the part. So even if we are having hearings in our homes, even if we are having hearings in our apartments, dressing for the part also really kind of sets the tone for the hearing. And maybe for the client, it might not be completely feasible to really dress up, but maybe dressing up uh top half, and you can still be wearing like MC Hammer pants below and the court wouldn't know, but at least trying to show respect for the formality of the process is really important. Also with appearance, this also connects to safety, but because it does happen where maybe in a video conference, or maybe while talking on the phone, the client may actually need to move. Maybe somebody's come into the room, maybe the connections get not that strong, and the call keeps going in and out. So the client may need to move. So really talking to the client about if they are going to be moving locations, thinking about like, um, once again, like what is visible, what are they uncomfortable with the court or opposing party being able to see. Also with moving locations, does that mean that they're gonna be like going through their kids' room, or are they gonna be walking by the dining table where the kids are having class? And thinking about some of those little, it doesn't seem like an obstacle in the moment, beforehand, but in the moment it can feel very distracting and very for some clients very exposing. So thinking about appearances in that way as well. And then what else? So this is where we would actually love to hear from everybody else, which is, we suggested some tips that we hope you found helpful, but what are tips that you have seen, that what are some best practices that you've been engaging with clients that you would like to share with the group here so that we can all be better at advocating for the survivors that we work with. And so obviously the Jamboard is not, I need to figure that out for our next time, but if you could share either in the chat or unmute yourself, we'd love to hear from you. And I know there's some really good attorneys on this webinar right now, so I'm coming after you.
This is Rania. I really like your suggestion to prepare clients for the fact that things can go haywire, because I just think the most important thing is to remind everyone to have patience. It's going to take longer. There are going to be issues. And if everyone just knows that going in, then when it happens, you can just take a deep breath and say, okay, we were expecting that. Now it's happened, you know. But at this point, I would also say to remind clients, you know, the courts and the clerks are used to doing Zoom hearings now too. So they're used to running into these problems too. So the court is not going to be shocked and horrified when, I mean, they might be frustrated, but it happens constantly. So just preparing everyone that that is the reality, and to expect it, and to expect it to take time, and to just be patient. I think that was good advice from your aunt, and I appreciate that.
Thank you, Rania. I see Nicole put in the chat, practice, practice, practice. This is so true. One time run through is not the same thing now as it may have been a year ago. So really, it's true. Practice, practice, practice. Any other practices that people find helpful?
I can read a couple of them. The tech tips and ideas about what to practice with the clients were super helpful. Asking the court for information about what to do if the call gets dropped is helpful. One attorney said, I work with a lot of clients who don't speak English, so hanging on to see when their case is called forward can be confusing, as other cases may not have interpretation. So it's helpful to continue messaging to check in so that the client should stay on the line.
That's very true. Also with interpreter cases, a lot of times, for example, when we're working with the client and I don't speak the client's language and I'm working with an interpreter, I'm using language line and I'm using the phone. And so the client may be more used to a phone interpreter with me, but reminding the client that the way we talk with an interpreter, the court and opposing counsel, you know, they have their own rhythm. So really talking through what does it mean to have the phone interpreter, the court interpreter over the phone. And also Zoom can be a little confusing initially for a client with a lot of folks popping on, and explaining to the client what to expect. What does it mean to have an interpreter via Zoom who's actually not next to you, who maybe you don't have a headphone that the interpreter is talking to. So really visually actually explaining to them what does that look like is really, really important. Any other tips?
If you have we got a comment that says, if you have an office space at work, having the client do the hearing there may feel more neutral and be better for dealing with tech issues, an extra office or conference room with the laptop. And then social distancing and masks, of course.
Great tip. And sometimes, you know, the best laid plans. I had a client who the night before her hearing, her toddler got her phone. She couldn't use her laptop because her kids needed a laptop for school. Her toddler got her phone and broke her phone. But she was able to message me from her neighbor's phone but the neighbor needed the phone and went because the neighbor was going to work. So I basically went to the client's house and we both were there on my phone on speaker. I don't know if we were the most safe being socially distant in her small apartment, but it was just, I mean, we took the precautions that we could take, but sometimes even the best laid plans, it doesn't work out. And so with that, we just want to remind you to approach the process, approach the virtual hearing with some humility and humor because mistakes happen. What people don't know is that cat filter, that was actually Yvonne during that hearing, but she did a great job of hiding her voice. I think many of you have already seen this video, but mistakes do happen, and I think courts understand it. The opposing counsel hopefully understands it, even if they may not be the most courteous with you at the time. But with some humility and some humor, I think we can all get through this. Are there any questions the last few minutes?
Yeah, Reethi, I know that some courts are also providing rooms that have a computer so that someone can attend a virtual hearing.
I think Rania just froze.
Sorry, I had an incoming call and it kicked me off Zoom temporarily. So maybe block all your incoming calls if you're attending via via phone. But yeah, I'm just wondering if that's something that, you know, the courts that you go to allow for having someone attend on Zoom, but through a court computer in a court rather than being in the open courtroom.
In the county, so actually, and before I answer that, Yvonne, do you want to drop the feedback survey in the chat so folks, because we're at time, so folks can take the survey if you have a few minutes. And then we'll also follow up with this PowerPoint and the survey as well. But to Rania's question, a lot of courts still haven't been creating that space. So it just depends on the courthouse. Some of it's been with the court library, coordinating with the court library. Some of it's been the individual judge maybe has a conference room or a lot like is able to identify a room in the courthouse. But then it's the court actually providing the device, and a lot of the courts are still not at that point. I mean, they're still trying to get caught up on technology, so not a lot of courts are providing devices. But if there is a county that folks are aware of where it's consistently happening, please do put it in the chat. Between the counties that we're in, we just have not really been seeing that yet, though I know that that's the hope. A lot of courts are talking about like being able to create these virtual rooms for litigants to be able to access. With that, we are at time. So in the PowerPoint, we just want to make sure that you know that we also have initiatives and special projects that we work on, including tech-enabled related cases that is very connected to the tech world and remote hearings. And of course, if you have any questions, please, please, please don't hesitate to contact us. Yvonne and my contact information is at the bottom of this page. And with that, thank you so much. Feel free to stay on if you do have follow-up questions or if there's anything you want to discuss, but I know we're at time, and thank you so much.
I want to read just one comment out loud. It's a double-edged sword. Remember though, if you block your incoming calls and you get dropped from a King County Superior Court DVPO hearing, we won't be able to call you back. That's from Commissioner Laird, so be careful.
Thank you, Commissioner. And thank you everyone for joining us. The next CLE is going to be March 18th. If you want to join us, it's going to be focusing on sexual assault protection orders. Have a good day. Bye.
Bye. Nice to see you.